In this, the sixth of our briefings on the resources super profits tax, I wanted to refer to the international law aspects of the tax. Under our Constitution, the Commonwealth government, that is the Crown, may enter into international treaties. That's in Section 51. Parliament has the power to make laws for the peace, order and good government of Australia with respect to international, rather external affairs. And we've entered into a number of treaties to guarantee foreign investment. It's strange that we needed to do that. It's usually required by unstable, or in relation to unstable governments. Foreign investors are very wary of investing in countries where the government is not stable, where the legal regime is not stable, so they seek international guarantees. Anyway, we've entered into these. And what we can expect is that if this tax is enacted, that many foreign investors will seek compensation. They will say, we came to Australia believing that you were a stable country, that you'd have company tax, and that we would pay royalties to the states. Now, they negotiated royalties with the states properly because the minerals are not vested in the Commonwealth government, they're vested in the state governments. Technically, the Crown in the right of the state rather than the Crown in the right of the Commonwealth. So the foreign investors have been good international citizens, they've paid their dues, but they expect, particularly in relation to existing investments, to be treated properly. Suddenly they're landed with a tax of 40% on super profits, so-called super profits, that is, anything over the long-term bond rate, 6%, which is strangely designated the basis, or the beginning of a super profit. In any event, the international investors, through their lawyers, will say, we're entitled to a remedy under these treaties. We want arbitration before one of the agencies of the World Bank, and our complaint is that we've been either nationalised, expropriated or otherwise affected, and we're entitled under international law to a prompt, adequate and effective remedy. That's the international law standard. And what could well happen is that orders could be made for compensation, running into billions and billions of dollars. What is certainly going to happen is that there will be litigation which will go on for a very long time, as has happened with mainly third world countries. Libya, for example, was tied up with a lot of this litigation for many years in the 70s. But there's one other aspect to this, and that is what is called sovereign risk. In brief, sovereign risk means the assessment foreign banks and foreign investors make about the stability of investing in a country, the legal stability, the political stability. We had a wonderful reputation from the very foundation of this country as a stable country, a safe country, a country where our word was binding, where you could invest. In the blinking of an eye, we've suddenly lost that. Through the government not doing the right thing, through it tabling, not in the Parliament, but before a media lockup, not only the Henry Tax Review, but its own proposals on that, not allowing debate, not allowing consultations and discussions, and presenting it as a fait accompli, as something not negotiable, except in relation to some transitional arrangements. Certainly the rate is not negotiable. Well, this will certainly drive away new investment, as we've already seen, but we are going to have very serious legal problems in relation to the existing investment, with a considerable danger that future governments, and therefore the future people of Australia, may have to pay very substantial compensation, running into billions of dollars, to correct this mess.